She did not slam it. She placed it, the way you set down something you have been carrying longer than it deserved to be carried, with the quiet finality of a person who has made a decision and is now simply executing it. The badge landed on 43 floors of polished mahogany without a sound. 19 equity partners at a Harding & Cross quarterly meeting watched Vivienne Cole open her laptop and turn the screen to face the room. Her voice, when she spoke, was level. What came out of her mouth in the next 90 seconds did not raise itself by a single degree. It did not need to. Because what Vivienne Cole had been building for 8 months was not an argument. It was a record, and a record, read aloud in a room full of attorneys who understand what records become, does its work without any assistance from volume. By the time she finished, no one in that room was looking at Warren Aldis. 8 years earlier. This is where it started. The first time Vivienne Cole walked into Harding & Cross's Chicago offices as a lateral hire, she came with a client list and a reputation that the firm's hiring committee had spent 3 months verifying before extending the offer. She had spent 17 years at 2 previous firms, boutique litigation first, then a mid-sized general practice, building the kind of track record that makes managing partners reach for the phone regardless of whether they have an open position. She had tried 31 cases. She had won 28. She had brought 4 clients with her to every transition, each one a relationship she had built personally, and all 4 had followed her to Harding & Cross within 6 months of her joining. She was 47 years old. She had grown up in Gary, Indiana, the daughter of a steelworker and a school librarian, had gotten herself to Northwestern on a combination of scholarship and work study and stubborn refusal to accept the ceiling that Gary had been told to expect for itself, and had spent the 2 decades since then becoming one of the sharpest commercial litigators in the Midwest, in the specific way that women who enter rooms expecting to be underestimated often become very good at their work. By leaving no margin, by documenting everything, by being so prepared that the only possible response to her in a courtroom was to agree or be embarrassed. Harding & Cross was the kind of firm that had photographs of its founding partners in the reception area, oil portraits in gilded frames, white men in dark suits looking out from the walls of a building whose architecture announced that the people inside it had always mattered. The firm had been founded in 1884. It had made its first black partner in 2001. It had made its second in 2018, when Vivienne Cole joined the equity partnership after a 2-year accelerated track that her sponsors described as merit-based, and that Vivienne understood to be merit-based in the specific way that things become merit-based after they have also been politically negotiated by people who needed her production numbers and the client relationships she brought with her. She had understood all of this. She had joined anyway, because the platform was real, and the resources were real, and the Daxton Corp account was real. A $14.3 million annual billing relationship that had been declining for 3 years under the management of a partner who was retiring, and that Harding & Cross needed someone to rescue. They had given it to Vivienne. She had rescued it. She had spent 4 years learning the company's business from the inside out, cultivating a relationship with their general counsel that went beyond professional into the territory of genuine mutual respect, and had turned a declining account into the firm's single largest client relationship by the metric that mattered most. What Daxton's general counsel actually said about Harding & Cross when other GCs asked for referrals. He said Vivienne Cole's name, unprompted, every time. This is the detail that mattered most about the account, and it is the detail that had been systematically absent from every internal document that described it. Warren Aldis had been managing partner of Harding & Cross for 11 years. He had built his career in the M&A practice, had a gift for institutional relationships, the kind cultivated over golf rounds and club memberships, and the specific network of a man who had attended the right schools and had never had to work to be in the rooms he was in, because the rooms had always expected him. He was not, by the standards of the profession, a bad managing partner. He ran meetings efficiently. He made decisions that the partnership generally found reasonable. He had a quality that certain kinds of leaders have, and that is often mistaken for fairness. He treated most people the same way. The problem was that the same way was calibrated to a specific kind of person, and Vivienne was not that kind of person, and the calibration produced outcomes that were not the same at all. Every quarter without fail, the compensation committee met. Every quarter without fail, origination credit, the attribution system that determined how much of a client relationship's billings were credited to which partner for compensation purposes, was reviewed and allocated. The allocations followed a logic that was formally documented and practically elastic. A partner who had introduced a client, or who had a prior relationship, or who had staffed a matter, could claim origination credit that reduced the credit of the partner who actually managed the relationship day to day. The system existed for legitimate reasons. It was also a system that, when operated by people with existing relationships with each other and existing assumptions about who was central to what, produced outputs that did not correspond to reality. Warren Aldis had been managing partner of Harding and Cross for 11 years. He had built his career in the M&A practice, had a gift for institutional relationships, the kind cultivated over golf rounds and club memberships, and the specific network of a man who had attended the right schools and had never had to work to be in the rooms he was in, because the rooms had always expected him. He was not, by the standards of the profession, a bad managing partner. He ran meetings efficiently. He made decisions that the partnership generally found reasonable. He had a quality that certain kinds of leaders have, and that is often mistaken for fairness. He treated most people the same way. The problem was that the same way was calibrated to a specific kind of person, and Vivienne was not that kind of person, and the calibration produced outcomes that were not the same at all. Every quarter, without fail, the compensation committee met in the same conference room on the 43rd floor, around the same mahogany table, with the same lake view and the same standing agenda. Every quarter without fail, origination credit was reviewed and allocated by 5 partners who had been making these decisions together for an average of 9 years, and who had developed, over that time, a set of shared understandings so thoroughly naturalized that none of them would have described them as understandings at all. They would have described them as the way things worked. The way things worked was that relationships mattered, history mattered, and the intangible quality of being known to the client in the right way, not just managing their matters, but being the face they associated with the firm, was attributed to the person whose presence in a room had felt most natural to the other partners when they thought back on it. When the partners thought back on client development meetings for Daxton, they remembered Warren walking Philip Garrett to the elevator. They did not remember, or did not weigh as heavily, that Vivienne had walked Philip Garrett to every subsequent meeting for 4 years. Memory is not neutral. Memory is the sediment of attention, and attention in rooms like this one had always flowed in a particular direction. Vivienne had noticed this in year 1. She had mentioned it once, quietly, to the partner who had been her primary sponsor in the equity process. He had said the system was imperfect, but the committee tried to be fair. She had nodded and said she understood and gone back to her office and opened a document on her laptop and typed the date, the conversation, and what had been said. She had given the folder a name. She had continued documenting. In year 2, the Hargrove manufacturing account, a client Vivienne had brought with her from her previous firm, a relationship she had held for 9 years, appeared in the compensation committee's quarterly report with a co-originator credit assigned to a partner named Marcus Ellison, who had attended one client dinner with Hargrove's CEO at Vivienne's invitation and who had been listed as a relationship contact in the client intake form Vivienne had filed because the form required two partner names, and Marcus had been the person she'd brought to that dinner. The origination credit split reduced her compensation for the account by 31%. She documented the split. She said nothing at the committee meeting. She built the Hargrove relationship further and billed more the following year and received the same reduced credit for a larger number. In year 3, a client named Preston Technologies, which Vivienne had identified, pitched, and won entirely independently, appeared in a quarterly report with a notation that a senior partner named Douglas Webb had a prior contact relationship with Preston's CFO, which was technically true in the sense that Douglas and the CFO had both attended a legal industry conference in 2019 where Douglas had given the CFO his card, which the CFO had mentioned to Vivienne as a piece of context when she first called him, and that she had noted in her pitch memo and forgotten about until she saw Douglas's name on the origination report. Douglas received 40% origination credit for a client he had met once at a conference and never contacted subsequently. Vivienne documented this. She requested a conversation with Warren about the attribution. Warren told her the committee had reviewed it thoroughly and that the prior relationship contact was a legitimate basis for partial credit under the firm's origination policy. She asked where the origination policy was documented. He pointed her to the partner handbook. She read the partner handbook that evening. The relevant section was 4 paragraphs that used the word discretion 7 times. She documented the meeting. She added the handbook excerpt to the folder. But then something happened that changed the calculation. In month 7 of year 4, Daxton Corp's general counsel, a man named Philip Garrett, whom Vivienne had worked with closely enough to have attended his daughter's college graduation in June, called Vivienne's cell phone at 11:18 at night. He said Daxton was reconsidering its outside counsel relationship. He said there had been concerns raised at the board level about billing efficiency and responsiveness. He said he was calling her, specifically, because she was the person at the firm he trusted to hear this directly, and to tell him honestly whether Harding and Cross was going to address it or whether Daxton should begin a transition. Vivienne asked him for 2 weeks. He gave her 2 weeks. She spent those 2 weeks restructuring the staffing on the Daxton matters, renegotiating 2 billing arrangements, and having 4 separate conversations with Philip Garrett that she documented in her notes and her follow-up emails and her matter files. She saved the account. Daxton remained. The firm collected $14.3 million in billings from Daxton that year, more than any prior year. At the quarterly meeting following that retention, the Daxton origination report listed Douglas Webb as co-originator with 45% credit. Douglas had attended 2 Daxton client meetings in 4 years. He did not know Philip Garrett's last name until Vivienne had introduced them at a firm event. He had not been involved in the retention conversation or the restructuring or any of the 4 client calls that had saved the account. He was listed on the original client intake form from year 1 because Vivienne, as with Preston Technologies, had been required to list 2 partner contacts, and Douglas had been the senior partner assigned to review new client onboarding at the time. Vivienne read the compensation recommendation in the quarterly report the morning before the partners' meeting. She sat with it for 11 minutes. Then she opened the folder on her laptop. She read through it, all 8 months. All 41 billing records, all 7 intake forms, all 6 email chains, all 3 compensation committee decisions. She did the math 1 more time. She had already done it 6 times. The number was consistent. She was owed by any credible accounting of origination and relationship management, between $340,000 and $480,000 more in annual compensation than she was receiving. The documentation supported that range. The documentation, if filed as an exhibit in a complaint with the EOC or a civil court, would support it in front of a judge and jury. She had not wanted to file a complaint. She had wanted the answer to be yes, yes, we see this. Yes, we will correct it. Yes, we understand what we have been doing without acknowledging that we were doing it. She had been giving the firm 8 months to arrive at yes. The quarterly meeting was the answer. The answer was no. She closed the laptop. She picked up her badge, the Harding and Cross Partner Access badge, the one that opened the floors where the firm's work happened, and she drove to the office. She sat in the partners' meeting for 47 minutes while Warren presented the quarterly numbers, the client pipeline, the lateral recruitment updates, the pro bono committee report. She listened with the patience of a woman who has spent 23 years in rooms where she had to wait for her moment and has learned to use the waiting. Then, Warren reached the compensation recommendations. He read Douglas Webb's origination credit for the Daxton account. Vivienne placed her badge on the table. The sound it made was nothing. The silence that followed it was everything. 17 partners who had been watching Vivienne Cole for 6 years had never once seen her do anything that was not completely controlled. The badge placement was completely controlled. That was the thing that made the room's breathing change. Not disorder, but its opposite. The specific, total composure of a person who has been preparing for this moment and has arrived at it. She opened her laptop. She turned it to face the room. She began to speak, not loudly, not with the performance of grievance that certain men in that room had been telling themselves, in unexamined ways, they would know how to handle. She spoke with the cadence of someone reading from a well-organized document, which she was, because she had organized it for 8 months with exactly this audience in mind. She named the Hargrove account and the 31% credit reduction, and the date it was allocated, and the name of the partner who received it, and the number of client interactions that partner had with Hargrove in the subsequent year, which was 0. She named the Preston Technologies account and Douglas Webb's conference card and the 40% origination allocation and the date and the dollar figure it represented. She named the Daxton account and Philip Garrett's 11:18 p.m. phone call and the 2 weeks and the 4 conversations and the restructuring and the retention and the 45% origination credit allocated to a partner who did not know the client's last name until she had introduced them. She named the total compensation differential across the documented period. She said the range was between $340,000 and $480,000. She said she had documentation for all of it. She said the documentation was in a format that would translate directly to an EOC complaint or a civil filing, and that she had not yet made a decision about which of those she would pursue, but that she would be making that decision based in part on how the firm chose to respond to what she had just said. Around the table, the room did what rooms of attorneys do when they are processing information they have not prepared to hear, and that they cannot dismiss, and that is being delivered by someone who clearly knows exactly what she is doing. One partner, the one who handled securities work, who had been at the firm for 19 years and had never once in those 19 years heard a compensation meeting proceed in this direction, reached for his water glass and left it there, untouched. Another looked at Warren, and then looked at the table's surface in front of him with the careful attention of a man who is studying something that is not there. Douglas Webb, whose name had been spoken 3 times, sat with his jaw set, and his hands flat on the table, and his eyes on a point somewhere between Vivienne and the window. which was the expression of a man who has decided that if he does not acknowledge the specific place where he is looking, no one will be able to determine where he is looking. The youngest partner in the room, a woman named Sarah, who had made equity 2 years prior and who sat at the far end of the table, and who would call Vivienne the following morning and say she had spent that evening reading every word of the origination policy twice, did not look away from Vivienne once. Warren Aldis, at the head of the table, was still. Vivienne said she would expect the response in writing by Friday. She closed the laptop. She picked up the badge from the table. She put it back in her pocket. She stood. She said she had a client call in 22 minutes and needed to prepare. She thanked the partners for their time. She left. 18 seconds of absolute silence followed her out of the room. Then someone, no one would remember who, later when they tried to reconstruct the sequence, said Warren's name. Warren Aldis sat at the head of a mahogany table on the 43rd floor of a Michigan Avenue building with the lake glittering behind him through the floor-to-ceiling glass. And he looked at the space where Vivienne Cole's badge had been. And he looked at the closed door. And he said nothing for a long time. The firm's response arrived Thursday. Not Friday, Thursday, a full day early. Which was the kind of detail that also says something. It was a letter from Harding & Cross's general counsel. The firm had retained outside counsel for the purpose, which was the second detail that said something, proposing a meeting with a mediator within 30 days to review compensation attribution methodology and explore appropriate remediation. It used the word remediation twice and the word discrimination 0 times. It was, as legal letters go, comprehensive and careful and written by people who had spent Wednesday night doing the same math Vivienne had done 6 times and arriving at the same answer she had. The mediation process ran 11 weeks. Vivienne was represented by an employment attorney named Christine Park, who had spent 15 years handling exactly this kind of case, and who told Vivienne in their first meeting that the documentation was the best she had seen since a case she'd litigated 5 years prior against a Wall Street firm, that had settled for 8 figures. The mediation produced a settlement that was confidential in its specific terms. What was not confidential, that Vivienne Cole remained a partner at Harding & Cross, that her origination credit on the Daxton account was formally restructured in the next quarterly report, and that the firm announced, 3 months after the mediation concluded, a new origination attribution policy reviewed and approved by an independent compensation consultant. The policy used the word discretion 0 times. Philip Garrett at Daxton Corp. received a call from Warren Aldis 2 weeks after the quarterly meeting. Warren told him the firm was undergoing some internal restructuring and wanted to confirm that Daxton's relationship with the firm remained strong. Philip said it did, and that he hoped the restructuring would not affect his day-to-day contact at the firm. Warren said it would not. Philip said he was glad to hear it, and that he looked forward to the next matter update from Vivienne. Warren said of course. He said he would pass that along. He passed it along. Vivienne received it by email. She read it. She filed it in the folder. Old habits. 1 year after the quarterly meeting, Vivienne Cole was appointed to the firm's compensation committee, the first black partner to hold the position in Harding & Cross's 140 years. She attended her first meeting and sat at the same mahogany table she had sat at for 6 years and listened to the new attribution policy being applied to a client matter. And when a question arose about how to handle an origination credit where 2 partners had both been involved in the client development, she asked a specific question about what documentation existed for each partner's specific contributions. A junior partner said he wasn't sure they'd tracked it at that level of detail. Vivienne said going forward they would. She said she could share a documentation framework that had worked well in her experience. She said she'd send it around before the next meeting. She sent it on a Tuesday morning from her office on the 43rd floor, with the lake visible through the glass and the oil portraits of the founding partners hanging in the reception area 43 floors below, where a different person was about to walk in for the first time and look up at the building and decide what they thought it contained. What it contained on the 43rd floor, in the office with the lake view, was Vivienne Cole at her desk with a badge in her pocket and a document on her laptop that had started as a record of what had been done to her, and had become, in the years since she'd placed it on a table, the foundation of something different. She opened the next file. She began to work.